The state of Illinois just submitted their response in our Supreme Court appeal challenging Illinois' so-called assault weapons ban. And their argument is exactly what we knew it would be: delay this case. It's not time, it's not right, it's not the right vehicle for this issue. They used some form of the word percolate 8 times. Now, I'm all about percolating coffee, but this is not coffee we're talking about. This is a Bill of Rights guarantee, and a right delayed is a right denied. But before I get into that, I want to set this up a little bit and provide a little bit of background before we jump into what they actually told the Supreme Court. So shortly after Bruen, we filed a lawsuit against Illinois' statewide so-called assault weapons ban and a local AR-15 sale ban in the city of Naperville. That was one of several lawsuits of that nature we filed all across the United States. The goal was to get it to the Supreme Court as quickly as possible and get a nationwide ruling applying Bruen to the issue of so-called assault weapons bans. We wanted a nationwide precedent striking down gun bans for good. The district court judge ruled against us, upheld the semi-auto ban, but the Seventh Circuit went a little further. They actually said the AR and AK style firearms are not weapons under the Second Amendment. They literally argued that AR-15s aren't guns. So naturally, we appealed that to the Supreme Court, and that's where we're at now. Now, we were not the only ones bringing this lawsuit. There are a total of 6 lawsuits against Illinois and 3 local governments in Illinois: Naperville, Chicago, and Cook County. So you have 4 government defendants, if you will, arguing that they should get to keep their gun ban. And they all get a chance to respond to our Supreme Court appeal, explaining exactly why the Supreme Court should say no, that they're not going to take this case. Illinois, Naperville, and Chicago all filed a joint brief, which I have here in front of me, and we'll get into that in a minute. But I have to call out the Cook County response just because of how they opened it. And here's what they said. In 1944, the Nazi German government began arming its troops with the Sturmgewehr 44, German for assault rifle 44, or more literally, storm rifle 44. This weapon was the first of what are today termed assault rifles. Now, first off, I have to say, that's a pretty cheap trick to try to discredit AR-15s by comparing them to the Nazis. But more to the point, all you have to say in response to that is, in 1938, Nazi Germany passed the Regulations Against Jews' Possession of Weapons Act, and we all know what happened next. If they want to talk about why we fight so hard for gun rights, it's because tyrants the world over start by disarming their people. So Cook County should think very hard about what side of history they are on here.
Have you looked at our caps recently?
Our caps?
They've got skulls on them.
I don't,
Hands. Are we the baddies?
So with that said, let's jump into the main brief, the one filed by Illinois and 2 of the local governments. They start theirs a little less radioactively. They start by pointing out that 14 states have passed this type of gun ban, and only 2 circuit courts have even considered it, and they both upheld it. They go on to say this: there is thus no conflict among the federal courts of appeal on the question presented. Meanwhile, the question continues to percolate in at least 7 circuits. In addition, this case is a poor vehicle to resolve the question presented because its interlocutory posture means that the record is still being developed and that the preliminary injunction factors not reached by the 7th Circuit provide alternate grounds for affirmance. And that's their case in a nutshell. And all that legal gobbledygook basically means this case isn't the right case to take this issue, and it's not the right time to take a case considering so-called assault weapons bans. Now they go on to say, paraphrase, "We know NAGR said that lower courts are disrespecting Bruen, but that doesn't matter. It's only been 2 years. Give us time." Which is exactly what we don't want to do, because the lower courts are unanimous in their absolute defiance of Heller and Bruen on semi-auto bans, and we want to stop that damage now, not turn them loose for a few more years. So a big part of their argument boils down to the fact that there's no circuit split. Now, what I mean by a circuit split is when you have, say, the First Circuit ruling one way and the Sixth Circuit ruling in the exact opposite way on the same issue. When you have that sort of thing happening, that really ups the priority level for the Supreme Court to jump in and to resolve that issue. And they're pointing out that no circuit courts have disagreed in their rulings on so-called assault weapons bans. But when they say that, they're making our exact argument for us here, because here's how we opened our case. Bruen called on the nation's legislatures to engage in a sober reassessment of their power to impose burdens on the right to keep and bear arms. The Illinois legislature ignored that call, And instead of tapping on the regulatory brakes, it stomped on the gas and passed a sweeping arms ban that included a ban on the most popular rifle in America. Illinois' reaction to Bruen is perhaps not surprising. After all, it is natural for the political branches to chafe at the constitutional constraints and to test them. What is surprising, however, is that after Bruen, the lower courts have upheld this and similar firearms bans without exception. This is surprising because Bruen emphatically called on the lower courts to stop their decade-long practice of giving undue deference to legislative burdens on Second Amendment rights. But in the teeth of that guidance, at least as far as firearms bans are concerned, it has been business as usual. That is our case. They're defying the Supreme Court. What are you going to do about it? In most cases, a circuit split on the issue does up your chance that the Supreme Court will hear your case. But on this issue, the lower court's unanimity in upholding gun bans in the very teeth of Bruen is actually our strongest argument in asking for relief now. Then Illinois goes on to say this. It has been less than 2 years since Bruen, and courts are applying it carefully to laws restricting semi-automatic weapons and ammunition magazines, many of which have been on the books for decades. And as the decision below, referring to the Seventh Circuit ruling, demonstrates, they are doing so in a manner consistent with Heller and Bruen. And they go on to repeat that later, saying that, quote, those courts are in good faith applying Heller and Bruen. Now, I don't know what planet they're living on, because what we're seeing in the lower courts is the worst of bad faith rulings that sometimes barely even give lip service to Bruen. It doesn't really get any worse than saying an AR-15 is not even a gun as far as the Second Amendment is concerned. And that's what the Seventh Circuit said. While they spend the most time arguing that this case should be allowed to percolate in the lower courts, they do actually back up that Seventh Circuit ruling and try to make an argument that the Seventh Circuit got it right. They say this: the Seventh Circuit faithfully applied the text and tradition test. It decided first that based on the record developed so far, assault weapons and LCMs, or large capacity magazines, are not arms within the Second Amendment's text because they are sufficiently similar to M16 rifles and the like, which Heller deemed permissible to ban. And they said that unironically. They literally said the Seventh Circuit was true to Bruen and ARs aren't guns in the same breath. We couldn't possibly have made a better argument to the Supreme Court to take this case. They are literally helping us right now. Now, we don't have time to go over everything in this brief. I wish we did, because we could roast it for days. But I did want to hit one additional highlight. While the lower courts have unanimously upheld gun bans in all the contested cases since Bruen, there have been circuit splits on different aspects of the Second Amendment arguments in play. And there's one example of that. That's Teeter versus Lopez, where the Ninth Circuit struck down Hawaii's ban on butterfly knives, since those knives are arms protected by the Second Amendment, according to that court. And they were right. They are. Well, we pointed to that reasoning as at least one example of a circuit court disagreeing with the Seventh Circuit's ARs aren't guns thought process. Now, Illinois said that didn't count because that case, quote, concerned a weapon that looks nothing like those regulated by the challenged laws, butterfly knives. In other words, that doesn't count. Those are knives. These are guns. But later on in the same brief, Illinois says Bowie knife regulations count as historical analogs, justifying semi-auto bans. In other words, it doesn't matter that a Bowie knife is a knife, and we're talking about guns here. If they regulated those then, and we can ban these now. So on the one hand, the reasoning behind a butterfly knife case doesn't count if it helps us, but they can point to Bowie knife laws all day long. And that's an example of the shoddy legal reasoning that these guys are reduced to when they try to justify a ban on weapons that are in common use for lawful purposes. And that's why we are ultimately going to win this case. Maybe not this specific case, but I am confident that we will see the Supreme Court strike down assault weapons ban nationwide. And we will keep fighting until they do. So what's next? We get to file a response to what Illinois just said here, and our lawyer is working on that right now. And then we will get a conference date. Now what that means is we'll get a date on which the Supreme Court justices will actually think about taking our case. And then we will hope and pray that they're ready to stop the lower court's trampling of our Second Amendment rights. Because a right delayed is a right denied. And it is time the Supreme Court recognizes that that applies to the Second Amendment too. That's where we're at right now. We will definitely keep you updated, and we would ask for your help. We can't do this without the support of law-abiding gun owners just like you. If you would please, Click the link in the description below to donate to our legal war chest to help us keep fighting against gun bans all over the country. And don't forget to like and subscribe to our channel, and we will keep you posted on what happens next.